The grounds for divorce in Maryland are now no-fault grounds. The first one is mutual consent. That means you and your soon-to-be ex-spouse agree on everything, from custody of your children to how your property is going to be divided to any kind of financial support you or your soon-to-be ex-spouse might have moving forward. If you agree on everything, you can get divorced right away. The next one is separation. If you and your spouse have been separated for 6 months, you can be divorced. And the last one is irreconcilable differences. This means that either you or your spouse or both of you believe that you have differences that you cannot resolve. In that case, you can get a divorce in Maryland. In general, when you're going through a divorce in Maryland, assets are divided equitably. So what is equitably? That doesn't necessarily mean equally. It means what a judge decides is fair. Now, most of the time, that is going to be equally. We're going to equally divide all of the marital assets. Anything that was earned or accumulated during the marriage, the judge is going to find a way to make sure that each spouse walks away with about half. Now, there are some exceptions. If things were premarital, if things were inherited, or things that were gifted or can be traced from any of those sources, they're going to remain the property of the spouse that inherited them, was gifted them, or had them before marriage. Alimony is starting to become disfavored. What that means is not a lot of judges are ordering alimony in the way that they used to. But for those that still order alimony, the courts are going to consider a variety of factors, the biggest one being need and ability to pay. The court is also going to consider things such as the reasons for the breakdown of the marriage, a party's ability to have retraining or to be able to go back out into the workforce and become self-supporting, the length of the marriage, any disability that either party may have, and their overall contributions to the marriage itself. So there's a lot of factors, and it's not a cut and dry answer in this area. We don't have a guidelines calculator where you can just spit it in and spit out a number like we do for child support. As for alimony, I always tell my clients, if you're asking for alimony, you should start figuring out how to live your life on your own terms, because you just never know. It can be a gamble. That doesn't mean you don't have a great alimony claim. It means have a plan B. In Maryland, child custody works by looking at the best interests of the children. The court has a number of factors to consider, and they're both codified, meaning they're in the law, and also they're in cases that we read and that the courts use to interpret the law. The court looks at these factors to determine what is in the child's best interest. Those things are going to be the gender of the child, the age of the child, what the child's relationship is like with each parent, whether or not each parent's going to be likely to help support the child's relationship with the other parent and the other parent's family, geographical distances between the two parents' households, the demands of employment on each parent, and a bunch of other factors that really do take into account how a child's going to do with transitions back and forth between the parents. For example, if you have a child that is not great at going back and forth, then a court might consider a schedule that's going to have the child one place longer and then the next place a little bit longer. The court really does look at what works for this individual child. A lot will depend on the child's relationship with each parent prior to separation. So make sure that you're considering that. In the District of Columbia, child custody is generally split. That means that is what the court prefers, that there is a default of joint custody of a child. Now, what happens if that's not in your child's best interest? In extreme cases, things like abuse or things such as if there is an addiction problem, the court will look at the best interest of the child and really consider whether or not that 50-50 makes sense in this case. But if you're the parent that wants the case to not be a 50-50 split, you're going to have to be prepared to point the court to reasons why that's not in your child's best interest. At the end of the day, all courts everywhere want to keep both parents in the child's life as much as possible. Not just because that's what's best for the child, but also because that's what our Constitution says. We all have the right to parent our children. If you're going through a divorce, we're here to help. We don't write endings, we create new beginnings. We're not going to focus on the end of your marriage. We're going to focus on your next chapter. Where do you want to be in 3 years? Let's make a plan to help get you there. Contact us now.